Pat, why don't we start our Smartcast on the best practices of termination. Here's our agenda, what we're going to be covering in the next several minutes. Red meat for lawyers. Lawyers are trained, employment lawyers, to look at certain things when employees come from an employer and they're angry. The employees are angry. And there are certain things that you should be aware of, if you're not already aware of, that in particular they know where the red meat is. And we're going to go through those things because we're an advocate for you. Top termination troubles, things that you can avoid, a termination test, some things that is kind of a best practice and things you want to employ. What the termination meeting should actually be like, who should be in it, who should not be in it, where it should be held, when should it be held. And then we'll get into some employment law with avoiding defamation claims in connection with employee terminations, and also post-termination separation dangers, and we'll kind of tie things up with severance agreements. Okay, red meat for lawyers. I mentioned that employment lawyers that do this day in and day out really have honed their skill in knowing what to look for to figure out if, in fact, there is a case. So when an employee is terminated from your organization and they come to you, or they come to the lawyer, they're angry. Now that we're going to talk about how we can minimize the disgruntledness of a terminated employee, and that helps, of course, mitigate the need for a lawyer. But these are the areas that you should be squeaky clean on, because the lawyers will, if in fact they feel there is a case there where the employer, yourselves, one of your managers, maybe messed up a little bit, said something maybe that shouldn't have been said, and it was said, well, the lawyers hear that, they can subpoena documents related to the hiring process. That is a minefield, my friends. That's a minefield of areas that there's all kinds of exposures there that if you're not doing it right, including the record keeping of the resumes and the employment applications, that can work against you. Job descriptions. Oh, real dangerous area. Here's why. No law says you have to have a job description, but if you do, it's got to be compliant with the Americans with Disabilities Act. Now, many of you know that I teach this stuff at the University of Wisconsin, and one of the exercises that in one of my HR classes that I have students do, and this is at the graduate level and at the undergrad level, and I found that it really doesn't matter. I ask the students to bring in a job description from where they work. Those are the best ones, rather than making one up from scratch and they're just thinking it up. But very well known in the Milwaukee area where I live, we've got some pretty large, big name not clients, but employers. And the employers that you would know if I mentioned their name. And it's unbelievable to find out what their job descriptions look like. Now, a job description should list all of the things that the incumbent is responsible for doing, but in that list, there is a short list, and the short list is the essential duties and responsibilities. That's the only thing that's required under the ADA. And so I've seen employers where they'll have a job description and they list every single duty, including, getting coffee for so-and-so practically. I'm joking there, but they list all of the tasks that the incumbent is responsible for as an essential duty. That is a killer. That's a kiss of death. You don't want to do that. So make sure that your job descriptions, and if you use Future Office Network, there's some really great wizards in there. Go in compensation, look under job descriptions, and there's sample job descriptions. There's sampled. You can cut and paste. You can build them your own. All kinds of tools, but they're all going to be legal. But job descriptions are an area where a lawyer will look at that, and they'll say, well, why were you terminated? And if it's not job related, you've got yourself a problem. Now, I know what you might be thinking, and there's a counter-argument to that, what I just said, and that is at-will employment. anything that's not in Title VII is fair game. So if somebody has blue hair, you don't like blue hair, well, I don't like blue hair, you're fired. Sounds just ridiculous, but that's not a violation of Title VII or any kind of other discriminatory act that's out there in federal law. It's just not. So you could do that, but it's not really job related, and that's where you're inviting a lawsuit. Even though